See if I can turn in the audience. Don? Oh, okay. Everybody back in? All right, meeting will come back to order. Mr. Dimucci.
Thank you, Chairman. I'd like to bring back up Mark Iden for a legal presentation.
Hello again, everyone. Just as a matter of housekeeping, we will present to Pat Tierney the exhibits which we have this evening that have been referred to, for example, the pattern book, the various slideshows and presentations. The way we had hoped to number them was the pattern book that Mike Dimucci discussed and held up as number 1. The families slideshow, John, Mike, and Kara, is number 2. The engineers slideshow is number 3, and Dick Rodowitz as number 4. So I just wanted to clarify that, do a little housekeeping. Okay, now you've heard some of what I'm going to say, but I'm trying to be a little more exact in the walkthrough. I'm going to talk about the IGAs, sewer and water, local control, things of that nature. And I'm going to try to take them in somewhat of a chronological order so you can follow all these agreements, because there are many, and I'm going to try my best to make it simple. We heard at the RPC a lot about IGAs, intergovernmental agreements, how they should be honored, why they're good for the local communities, you know, how the local governments cooperate with one another. The IGA that was consistently referred to at the RPC, I believe, is the Hawthorne Woods North Barrington Boundary Agreement. And I'm going to give you a summary, but we've encouraged everyone to look at our website, dimucciproperty.com.
This is Mark Iden.
All of this information has been there for several months, and it's very easy to bring up. And of course, you have all your materials from the county, and so I was assuming that's readily available to you. The Hawthorne Woods North Barrington Boundary Agreement was first executed in 1999, and pursuant to an exhibit, was Exhibit B Development Standards. It discussed specifically the Dimucci property and said no less than 35 or more than 50 acres shall be developed pursuant to a planned unit development as retail development. The remainder of the property of approximately 110 acres, that's the 110 minus the retail, shall be developed as residential with a mix of single-family dwelling units, townhomes, and condominiums. So the first agreement was 35 to 50 acres commercial, and the balance various forms of residential. That agreement was amended in 2002, and it reduced the retail area to 25 acres, and it shifted it slightly south. So the status of the IGA then was, as it was amended, 25 acres retail and the rest residential. In that agreement, there were revenue sharing provisions and things, some financial interchange between North Barrington and Hawthorne Woods. But the one thing that was totally missing was any discussion with the owner. And the county was not involved early on. And when they were called upon to be involved, it was requested that they sign on to this agreement. And they expressly refused to do so. The framework plan, if you take a look at that, says IGAs are a good idea, but they're a good idea when everybody is at the table day one. Owner, county, municipalities, that sort of thing. That's not how this was done. Now, in that agreement, all of the planning jurisdiction was given to Hawthorne Woods for the Dimucci property. Route 12 is roughly the dividing line for the boundary agreement, and if there were ever an annexation of the Dimucci property as between Hawthorne Woods and North Barrington, the property would go into Hawthorne Woods, and then the agreement talked about things like revenue sharing and protecting the village. And that'll be important later, I just want you to recall. Then you would expect, when you look at those agreements, that comprehensive plans would naturally follow those plans. And you've heard previously, but I'll reiterate, the Hawthorne Woods Comprehensive Plan of 2004 stated that the maximum area would be 50 acres provided that sewer was available. And it moved the commercial area back in a position where it would align with Timberlake Road. Now, I want to read a brief portion of that comprehensive plan to tell you how it addressed this site. It says, this site, which is over 100 acres in size, lies in unincorporated Lake County. Provided that an acceptable alternative to conventional septic system waste disposal can be achieved, then the village envisions that up to 50 acres of the site could be developed for commercial use. It is envisioned that residential development will be at a density that is consistent with that of surrounding residential development. Now, we heard at the RPC that that was a mistake. It was a scrivener's error, they called it. And they said that they took the actual map of the comprehensive plan, scaled off the area that was shown in red, and you saw some of that earlier, and found that it was far less than 50 acres, perhaps the 25 acres in the boundary agreement. But I have to say, when you include a statement that says you can move up to 50 acres if you get sewer, that's pretty much evidence of what you intended. You're 25 acres, now you can move to 50 acres because you have sewer. It just doesn't make sense that you would go to the effort of writing this down and then try to scale your own plan and say, oops, the plan picture controls. So our conclusion is that the Hawthorne Woods Comprehensive Plan would allow up to 50 acres of commercial development. So this is the first departure from the Hawthorne Woods North Barrington boundary agreement, because where that agreement was left in 2002 was 25 acres. Subsequent to that, Hawthorne Woods passes a comprehensive plan that says 50 acres. So essentially the IGA, which is touted as being this document which should control everything, was not followed. Now, the drawing for the North Barrington Comprehensive Plan doesn't include the Dimucci property, and I would assume that the reason for that is because the planning jurisdiction and annexation rights were ceded to Hawthorne Woods. Now, there is a text to that, I believe. There was testimony at the RPC meeting that said it would allow up to 16.8 acres of commercial, this being a North Barrington Comprehensive Plan. Where the .8 comes from, I don't know. It seems like a lot of micromanaging. But just that statement means they didn't comply with the IGA either, because where the IGA left was at 20 acres. Now they're talking about 16.8 acres of commercial in an area for which they had ceded jurisdiction for planning and annexation purposes. There's also, what you saw earlier, the BACOG plan, and BACOG is an organization I think you're all familiar with, and it is a way of trying to foster intergovernmental cooperation, which is admirable. The BACOG plan shows all of the property as commercial. Now, there was a clarification at the RPC by the president, I believe, of BACOG, who said, well, it really didn't mean that. It was kind of more of a mixed-use concept, but it did mean that substantially most of the property was considered commercial, not just 100%. Without reading too much into it, I would say that it's a fair assumption that at least 50 acres was envisioned by that plan when it showed 100% commercial. And I can only rely on the document. I'm not going to try to put words in people's mouths. You'll probably hear from the president of BACOG anyway during subsequent discussion. And I'd also note that in the Route 12 Corridor Council's plan, that was the consortium of several of the nearby villages in the county and MCMS sort of thing. That plan shows the business designation right at the same area that we show our development area. So the first observation is that this IGA, which is touted to, is something that should be followed because it's what the local government wants, was never followed. Look at the plans. This agreement was honored in the breach. So it's my contention that you have an IGA, first of all, that there's no jurisdiction on the IGA because you have to go into one of the villages to be governed by it. But even if you did, nobody followed it. So there's confusion. What is it? Is it the IGA? Do I have to deal with North Barrington and Hawthorne Woods? Can I go up to 50 acres in Hawthorne Woods or not? Quite frankly, I don't know. As part of that discussion, there was a strong argument for local control. Why don't you leave it to the municipalities? Well, the Dimucci family started with the municipalities. They started with North Barrington, went to Hawthorne Woods. You're probably all aware of somewhat of the history of what went on. But the original intent was to annex and to have an annexation agreement that spells out the development parameters and things of that nature. That was many, many, many years ago. The response was the IGA. And the IGA starts at 35 to 50, it drops to 25. It looks to me like they're trying to manage the development of this property. And that's their purview, but it seemed like the IGA was out there to very much influence what would go on with this property and what people would see if they tried to come in and develop this property. And the IGA was itself basically a settlement agreement between the two villages. When there was litigation between the villages, the matter was settled with this IGA agreement. And that had to do all in the time span and thereafter of this Taubman Mall that you've probably all heard back in the, I think it was the late 90s. And the effort was being made to never have that quote-unquote problem arise. Well, this is not the Taubman deal, but believe me, from what I've heard, I think people they've got that stuck in their mind that this is the same thing, and it's not. Well, where did that leave us? Again, we have the IGA at 25 acres, we have the comprehensive plans all over the place. When someone argues for local control, why would we go to the villages? We're in the county, and we have this series of agreements and plans that don't jive with one another. I mean, there would be no sense in going there, nor would anybody who was interested in the property, a third party, in the event there were a developer waiting in the wings. They would look at this and say, it's inconceivable that you would go to a municipality. There's also out there, which you may or may not be aware of a lawsuit by various parties trying to annex a strip through the Dimucci property so that North Barrington can obtain some jurisdiction over a portion of the property and then bring in Valentine Manor. Well, if the judge says, okay, I'm going to now find all of this correct, and what the judge does is he refers it to the municipality. At that point, if it occurs, North Barrington's going to have to decide whether they want it in their village or not. If they say no, that's great. If they say yes, they're breaching the IGA again. I mean, they've ceded planning jurisdiction and annexation jurisdiction. So I don't know where that's going, but that's another troubling sign. The county, as I said before, was asked to join into this IGA. They were not involved early on. This was only later. And they declined to do it on that basis. The North Barrington Comprehensive Plan states the overture to Lake County was not successful. Our plan already reflects what the communities have stated they wanted in their comprehensive plans. We have, well, I'm reading the facts. The facts are, take a look at the relevant documents. You'll see Hawthorne Woods, Baycott, Route 12 Corridor Council, they all have this commercial component, some of which is equal to and some of which is greater than the commercial that we see. On this issue, it's just very risky to deal with the villages. And why is it risky? For all the reasons I stated. You have all these agreements that none of which agree with one another. And we're supposed to go to these villages and say, well, I don't know, where do we start? We've kind of had enough of all the things that have gone on, which I believe were an attempt to affect this property adversely. Now, there are other IGAs, intergovernmental agreements, and these involve sewer and water. And they were touched upon briefly, but let me be more specific. There was a boundary agreement between Hawthorne Woods and Lake Zurich back in 1998. And it established a boundary line where Lake Zurich would be allowed jurisdiction south of the line, Hawthorne Woods north of the line. Well, the Dimucci property happens to lie north of that line. In that agreement, they said neither village will service territory where the other village was given jurisdiction with sewer or water without the other party's written consent. So that would mean that unless Hawthorne Woods consented, Lake Zurich could not supply sewer and water to the Dimucci property. In 2003, Lake Zurich signed an agreement with Hawthorne Woods, and it allocated specific population equivalents, PEs, to Hawthorne Woods for specific parcels, one of which was the Dimucci property. And the idea was that Lake Zurich said, here's some of our capacity, and you can use it to service these various properties, and we, Lake Zurich, will not. Then moving on in time, and it's going to kind of jump around a little bit here, but in 2009, North Barrington, Lake Zurich, the county, and in another agreement, Windstone, entered into an agreement that discussed a sewer line that went from Lake Zurich north along Route 12, basically to the southwestern corner of the Dimucci property. Originally, it was intended to solve a problem in the Windstone subdivision, but that agreement was designed as a regional sewer line and not for the one purpose, and I'll read this to you very quickly. It says, all parties agree that the downstream sewer force main line easterly of Illinois Highway 12 is intended to be and shall be a regional sanitary sewer. Said downstream regional sewer force main is sized with a flow capacity sufficient to serve other neighboring properties as depicted on Exhibit F. This is an exhibit to that agreement. And you can see the property described as permitted future connections. The more northerly-most parcel is the Dimucci property. Included in that is Valentine Manor. And then there is the Mount St. Joseph facility. I'm not sure if you're all familiar with that, but it is a very large tract of land that is used for institutional purposes. In the institute, I think it's zoned institutional. But it says, attached hereto and marked Exhibit F is a map identifying those parcels or tracts of land that the parties agree may be permitted upon compliance with all federal, state, and local laws and upon payment of the then applicable Lake Zurich and county connection charges to connect to said downstream regional sewer force main for sanitary sewer purposes. So what all that means to me is that the line which is in that runs to the southwest corner of the Dimucci property, being originally installed to solve a problem with Windstone, was deliberately at the time that that line went in, also to serve these permitted future connection properties. So it is clear by agreement that included North Barrington that this line was designed and constructed for these additional properties. And I will note that at that time, the current president of the village of North Barrington was shown as a trustee to have voted in favor of this agreement. Moving ahead then, in 2009, there was an issue that was raised with the allocation by Lake Zurich of some of its PEs to Hawthorne Woods. And you have to understand how this line works. It flows from Lake Zurich quite a long way to a county treatment plant. And since the county owns the permit to treat sewage, they're also concerned about what ends up in that plant. So the county argued that if Hawthorne Woods is going to enter into an agreement with Lake Zurich, the county also has to have a say in that, because Hawthorne Woods sewage would flow into the county plant. And they want to ensure that there are not types of sewage that flow in that pipe into the plant that would be impermissible. And I'm not a sewage treatment engineer, but I think there are certain toxins or chemicals or things of that nature that they don't want in that plant. So what happened was, and let's see if I have it here, an agreement was entered into between the county and Hawthorne Woods. So Hawthorne Woods was going to supply sewage capacity through Lake Zurich to the county plant. The county wanted to enter into an agreement with Hawthorne Woods, consenting to this supply of sewer services by Hawthorne Woods. And that agreement states, the village, being Hawthorne Woods, agrees that notwithstanding any provision to the contrary within the Hawthorne Woods Lake Zurich agreement, that's the one where Lake Zurich gave PEs to Hawthorne Woods, some of which were specifically allocated to the Dimucci property. Lake Zurich shall have the right to contract with the county for the provision of sanitary sewer service to the Taubman parcel, as it was then discussed, that is the Dimucci property, or such portion thereof, so long as such parcel or portion is within unincorporated Lake County. So that's saying that the county essentially can also service the Dimucci property while it remains in the county. If it goes into Hawthorne Woods gets to do that. It says, the village further agrees not to object to such service, and that if so required by Lake Zurich to effectuate such sanitary sewer service to the Taubman parcel, and to support an amendment to the Hawthorne Woods Lake Zurich agreement expressly authorizing such county service to the Taubman parcel. Now, what we have to do then is jump back, because originally the agreement between Lake Zurich and Hawthorne Woods is, I can't go in your area, you can't go in my area with sewer and water unless we expressly consent. Well, this agreement with the county says that they won't object and they will consent to sewer service directly from the county, as long as the property remains in the county. Well, it does. I don't know whether Hawthorne Woods has responded to a direct written request by Lake Zurich to service the Dimucci property, but under the agreement with the county, Hawthorne Woods is required to so consent, and I don't think that consent has been given. But it was on this basis that Lake Zurich talked to the Dimucci family and said, all right, well, we have an obligation by virtue of this agreement. No, I'm sorry. They said we have the right by virtue of this agreement with the county to service the Dimucci property while it's in the county. They send a letter. I don't think Hawthorne Woods responded. But on that basis, after reciting in this agreement between Lake Zurich and Mr. Dimucci's group, it laid out all of these agreements. It recognized that they all existed. And then it said, you know, pursuant to the sum total of all of this and the agreement between Hawthorne Woods and the county, that they would enter into an agreement with us that as long as we're in the county and we develop in the county, we can obtain sewer service through Lake Zurich. Now, where does that leave us? We have a sewer line in place with sufficient, we were reserved, as Kim said, I think it was 705 PEs, which we think is sufficient for the property. The pipe is there. We have the agreement with Lake Zurich. Lake Zurich has studied all the agreements and has determined that they have the authority to do so. And so, in my opinion, and in the opinion of several others, this property, sewer service, is available to this property in the pipe that is currently on the ground. Now, the Lake Zurich agreement went one step further, and they said, at such time as Hawthorne Woods consents, because you recall that the Hawthorne Woods Lake Zurich agreement said, I won't supply to your territory, you won't supply to mine, sewer and water, unless there's express written consent. So Lake Zurich says, okay, but we'd also like to give Dimucci water, and would you consent? And I don't think there's been a response to that letter. And on that basis, Lake Zurich said, look, that agreement's going to expire in 2018. And at that point, we're free to do what we want. And we agreed to provide you potable water from Lake Zurich to the property. You have to construct the pipes and all that stuff. But not only do they agree, but if a development has occurred on the Dimucci property prior to that time, Dimucci must connect. They don't have the option. They have to connect. They have to put the sewer line or the water line in the ground. If the property develops after 2018, then same rule applies. They have to get their water from Lake Zurich. Now, before 2018, if Hawthorne Wood says, well, we won't consent to this, the Lake Zurich has said, well, it's fine for you to do alternative water sources, whether that's from some other public water supply, through wells, however, as time progresses, that could be accomplished. We have to, however, if development occurs prior thereto, construct all of the lines on the property such that they terminate at the southwest corner of the property near the same sewer line, so that the connection can be made easily and seamlessly once the pipe is in. So, in my mind, I don't know when development's going to occur because we all know what's going on in the country. But you have to understand that first someone comes to you and says, now that all of this is cleared up, I think I could safely buy this property, or we could develop this property subject to all the things that we're asking here. And what would they have to do? There'd have to be a contract. The contract would be contingent. They'd have to go in, do their due diligence, prepare their plans. Before they even do that, they get their co-tenancies, which is, you know, I don't know, whatever department store there is won't go in unless there's a restoration hardware and a this, that, and the other thing. And restoration hardware says, I won't go in unless the gap is over here and something. So it's a puzzle that you have to put together, and it doesn't happen all that quickly. I represented Paul and McEwen, who were the developers at Deer Park Town Center, and I recall how long that process took and how difficult it was. But once you've got your tents lined up, and once you've done all the work, engineering, architecture, landscaping, building design, and that's no small task, that takes a long time. And then you have to put in your infrastructure. You have to grade the site, put in all the pipes, do all those things. It's entirely possible, although this isn't conclusive, that this property wouldn't be available for retail, commercial, whatever use until 2018. And it's a big tour, and you know, who knows what this economy could take a little bit for people to realize that the property is now developable and seek the property out. So it could happen that before that time, someone could move more quickly. Let's say that's 2015. Well, then there would be reliance on the alternative water sources, whatever they may be, and they would be disconnected 3 years later. So that's how that whole thing falls together. So the way we see it, we've got villages which we don't think we can deal with. We've got agreements that we don't know where to start. We've got the property in Lake County, never was in any village, always has been in Lake County. We've got a county with very good planning resources, very good staff. And so there is no incentive, there's no reason to go into the local areas and say, you know, please help us. I mean, I just don't see it. Now, then when we came in and we asked for our zoning, as I explained earlier, this really is a zoning case. Now, it ended up with this special use and plan development concept. And there are various standards that have to be met. And they're detailed in the UDO. And the UDO pretty much tracks the law on what standards that you have to meet. Now, I'm hoping that all of you, and I can see some on the desks, have our application document. It's on the county website, it's on our website. And we go through all of these standards: zoning, conditional use, plan development. So I'm not going to walk through every one of those. I just want to incorporate all of that in my testimony as the application being made part of the record, which I guess we'll call number 5. But I do have some additional comments.
All right, quiet, please, thank you.
I don't understand. The zoning that we're looking for, the standards that the county has in the UDO, pretty much based on a series of cases generally known as the LaSalle standards that set forth the basis for a rezoning. Now, again, we've got that all in our application, but there's a few highlights I want to make. We filed the application back in February or so, and there's been a lot of activity since then. The first standard is that discusses the existing uses and zoning of the nearby property. Well, the first point I would make is, as you saw in John's presentation, there is a significant trend of development up Route 12 that leads to commercial development and, in fact, little or no residential development. The predominant development along Route 12 for the last 10, 20 years has been commercial, from the south to the north. The local bodies have recognized this in their plans. I talked about that earlier. In the immediate area, if you look closely, you've got commercial to the north, you've got residential to the east and northeast with very significant setbacks. You've got institutional uses, school, Mount St. Joseph, you've got commercial to the west, and you have basically the largest highway in western Lake County adjacent to the property. It's a 4-lane highway with, I'm sure you're all aware of Route 12, with a significant median in the middle. The impact of this is that this is a mixed-use area. You can't claim that this is just an entirely residential area that should remain residential forever. The macro trend is commercial up a major highway. The micro trend is an area that has mixed uses. It is not predominated by a single use. Now, some of the plans that you see, like some of the comprehensive plans, you'll see that, well, we have commercial, but we have buffers. We have single-family residential along Old McHenry, and then maybe some multifamily, and then the commercial. It's a transition sort of thing. And that makes sense. I've done a lot of developments that way. But we just bypassed that and said, let's make it open space. Now, if people insisted and said, no, we have to have that residential transition, I guess so be it, but you're going to have a platted subdivision with a lot of lots that will never sell, and you won't have the open space that we have, and you'll have impact on the schools. if our analysis of the trends, both locally and along Route 12, didn't hold up, you'd never have regional commercial areas like Deer Park, which I was heavily involved in, which was Ethel's vegetable farm and Bill Annist's property, and there was, lo and behold, that nobody knew was a cemetery that was there that was unmarked. And then you wouldn't have the various areas that you see moving up the road, not just Route 12, but in all the other areas of the county. You could never plan any kind of regional commercial development if you just said, you know, you can't build commercial here because there are some neighborhoods, which I respect, but you know, you have to build these things somewhere. You build them on highways. If I'm a county representative and I'm trying to do good planning, what am I looking for? A series of strip centers up and down Route 12, or am I looking to make something nice? Am I looking to make high quality, low density, a lot of open space type development? And how do you get these kind of developments? You have to plan for them in the appropriate places, and I do believe that this is the appropriate place. Now, we had another instance of this, a project that was never built, but I'll just call it out to you. That was at Route 132 and Route 45 in Lindenhurst. It was to be called Lindenhurst Village Green. And in that, we had a commercial center, and then radiating outward from that, I think, was multifamily. Nobody stepped up and volunteered to make all of that land open space. It abutted forest preserve, residential areas, mixed-use areas, and I think there was a hospital satellite facility there. But it was very much the same thing as we have here. And that was approved and platted. The economy hit the tank, it didn't happen. But that's an example of an area on 2 state highways that is found to be an appropriate place for this sort of thing, rather than put it, you know, a quarter mile or a mile up the road on one side of the street, and then decide that, well, maybe we should spread it out because we don't like it stepped and we have a lot of strip centers. So I'm just raising that as an example. The second standard is the extent to which property values are diminished by a particular zoning restriction. Well, as was stated before, along Route 12, there hasn't been any single-family development in 20 years. There was a multifamily development that's south of the property by a mile or so. But there's been nothing built the way this property is zoned. I mean, this is for 80,000 square foot lots. I think the site capacity would allow about 40 homes on the 110 acres. You heard Mr. Rodowitz state, as a licensed appraiser, that the difference between values for single-family homes and the zoning that we see is quite substantial. There is no market for single-family homes, and I'm not sure I could identify a lot of people that would want to live 2 acres next to Route 12 and build a new house. Now, the third requirement is well, I know I wouldn't put it that way. The third requirement is the extent to which the destruction of property values of plaintiff, and when they say destruction of property values, they're meaning if you keep it as it's zoned, you in essence destroy the property value. Promotes the health, safety, welfare, morals, and general welfare of the public. In other words, we should keep it where it is, because doing so promotes health, safety, welfare, etc. Well, first of all, the destruction of property value, keeping it the way it is, as I just stated. But when you look at the property as it is, it's single crop farmland with totally unregulated runoff. In lieu of that, you could have a very highly regulated, very upscale commercial development, significant open space, and, which is very important in the law, significant tax revenue to local taxing bodies, some of which Kara discussed. And when you remove residential and you keep only the commercial, convert the residential into open space, there's no cost to educate additional students. It's all revenue with very few, if any, costs to the taxing bodies who receive that revenue. The fourth standard is very similar. It's the relative gain to the public as compared to the hardship imposed on the property owner. The hardship being keep it as a state with no marketable possibility. Well, in this instance, Mr. Roderick has testified that development is not going to adversely impact the values of the residences. And again, the public has gained the increased tax base, open space, local services provided by what is built there. You're going to have very much improved stormwater management as opposed to unrestricted runoff of topsoil. Enhanced aesthetics, all of those things. So, okay. Now the next test is the suitability of the subject property for the zone purposes. Well, the property is relatively flat, has very few natural resources. As Kim stated, it indeed has suitable soils, and if it doesn't, you can use the example of several of the developments in the area where soil can be remediated, and the property is suitable from the standpoint of having a major highway, having a major county road, all of those things. They all stack up to say that all of the services and all of the property characteristics are suitable for the proposal that's being made. Another standard is the length of time the property has been vacant as zoned, considered in the context of development in the area and the vicinity of the subject property. Well, property has always been for sale, and there are a lot of people that know this. There have been a lot of people that have approached the Dimucci family saying, we'd like to do this, but we don't like what we see, we don't like all these agreements, but let's take a run at it. Well, nobody came and said, we want to buy your land, we want to put residences on it. It never happened.
Yes, it did. Yes, it did.
The property has remained vacant because nobody wants to come in and put an all residential development on that site. The law states that even if you bought it knowing the zoning, that's not a relevant consideration. What is relevant is what the zoning should be given all the standards. Now, there have been some proposals where a developer comes in and says, I'd really like to build some retail or whatever on this property. I'll throw in some residences because that's what everybody thinks is going to be a requirement, some kind of buffer. And in all cases, these the residential proposal was a throwaway. It was like, we want the commercial. If someone wants residences, we'll plat them out. Maybe we'll make some money, maybe we don't. But of course, we're solving that problem by removing that in favor of open space. The next item is the care with which the community has undertaken to plan its land use development. Well, it's really the county that they're referring to, but I'm going to refer for a second to municipalities. They've adopted plans, they were fairly careful, and those plans, as I've discussed, recognize a commercial on the property and the location where we have proposed it. You, on the other hand, will have to make up your own mind, because this is directed at the care with which you have done planning. And I submit that being a countywide body with regional impacts and layouts in your minds, you're not a village, you don't have parochial concerns, you have a broader scope, that you'll have to make up your own mind whether this is appropriate there. And as we understand it, the staff is making the recommendation that this is appropriate. And the last item is the evidence or lack of evidence of community need for the proposed use. Well, the first thing I can say is there is no need for residential, and that's evidenced by the marketplace. The community need is apparently recognized by the communities in the area. Look at their comprehensive plans. They're saying commercial is appropriate. So somewhere along the line, they had to make that analysis that there was a need there. Now, the final piece of this puzzle is the fact that this is a special use. And in or conditional use, I'm not sure what it's called in the county, but conditional use allows the county to impose significant restrictions on their approval. We have been submitted and have reviewed and have commented on, I don't know if it's 16 or 18 pages of conditional use provisions, addressing a lot of the matters that have been raised so far through the RPC process, and of course through the county's own sense of planning, saying this is what should be and this is what shouldn't be. And we, so far, have not had any quarrel with any of these things. We believe that if we as owners are allowed to plan the property, we will take significant cuts in the density on the property and will agree to specific conditions that will go with the conditional use permit. If somebody else comes along and says, I want to do something different, well, then the conditional use permit expires and that person gets to start over. So this is going to be a large measure of the control on this property. If you look back on it now, we've got a 110-acre property. We have agreed to use half of it. Instead of having transitioning buffers by residential and the costs that they impose on the taxing bodies, we're proposing open space. This allows for a significant separation of the property from other uses. The property development area is along Route 12. It's aligned with Timberlake Drive, as it should be. There'll probably be a traffic signal there. We'd have to do more studies. So, as an owner, we can make these concessions. But, you know, I can't imagine if we're unsuccessful here, that any future developer is going to come along and talk about these sorts of things. We're going to enforce their rights under the law. And so I submit that this is probably the best proposal that you'll see. With that, I'll conclude my remarks, but one thing I do want to say, I don't know if procedurally this is necessary, I think it's in your rules, but when all of this is said and done with anybody who challenges this proposal, we'd of course like the right of rebuttal in the end. And what I'm assuming is now we're going to have far more hours than we have spent with testimony from the public. I don't object to that in any way. But what I don't like to hear is we took the stage, we had all the advantages, they had no time to present anything. They're going to have a lot of time. And I also want to say that at one of the RPC meetings, there was a table set up for staff just like this. And there was a table where the developer, not the developer, the owner, could put their computers and things of that nature to make it easy to go back and forth to the microphone because they were the applicant. And there was a large complaint from the audience, and not unreasonable, that, you know, why is the developer being given a special place in the room? Well, the first thing I noticed tonight when I walked in is this. Tables were reorganized, everything was changed, and nobody's got a comment about that. So I just want to say, what we're going to do in this process is we're going to be reasonable, straightforward, no tactics and that kind of stuff, and let's just get on with the business of planning something right. We think we've presented to you a good proposal, a fair one that is a hit to the owner. I mean, he's not maxing out his site, so I request that we work together and try to make a good development of this. Thank you.
Thank you. We're going to go to about to 9 o'clock, and then we will continue. We got Mr. Dimucci.
Yeah.
All right, you want to finish up?
What's up?
No, Mr. Braithwaite?
Yeah.
No, you don't have the floor. Let him finish, please.
Please finish.
Okay, thank you. We are finished, and we appreciate your time, especially members of the board. In conclusion, I'd just like to say that everything that you heard tonight is on our website. We've said it many times. The documents you heard about, sewer agreements, intergovernmental agreements, it's all on there. You can visit at any time, dimucciproperty.com. It's quite a lot of information, but it is available, and I know you guys have it, but I'm referring to the members of the public. So thank you very much. We appreciate your time.
All right, thank you. As I said, we're going to go to 9 o'clock, and then we will continue to another date. But right now, I'd like to open up the questioning to the board. John?
There you go. I'll just sit back there.
Better get closer to the microphone.
I'll refrain for now.
Carol, you ready?
No, I'm not ready. I really anticipated coming here this evening and just listening. Thank you.
Greg?
Based off the presentation that I've seen so far, I don't have any questions. I'm sure some questions may come up as we get further into it, but I don't have anything at this time.
Jerry?
I have some questions. The gal that Kim was there from the engineering, it was a little hard to understand you, and you were talking about the soils. Now, you had two highlighted, a red and a blue, and then the rest of the property didn't really have have much on it. But in relation to those soils, you talked about other developments that had been built on similar types of soils, and that arrangements were made to accommodate the buildings of bridges, buildings, whatever. On that property, is the lower right-hand corner, and you might be trying to find it, is that where the water is on that property, or is it just to the north?
Well, the property is dry. There really is no water on it.
On the north part there?
Oh, that's not water. That's at the north corner? Is that what you're talking about?
Yeah, they were saying that area wasn't.
Well, there's a floodplain in the northwest corner.
Okay, that's just a floodplain.
Right.
And so then what they're showing in their conceptual idea of water and retention ponds is gonna go to the north and kind of circumnavigate. And where does Squaw Creek come in on that?
Well, Squaw Creek is the release rate that we're restricted. We're restricted to a release rate that is.
And so all the property flow, water flow is going to be from the north to the southeast?
Well, that plan is just a conceptual plan, and I don't think that is exactly what it's going to look like when the property is going to be developed. We'll do a detailed topographic survey of the property and determine exactly where that ridge line is of the area that's distributary to the north and whatever else is tributary to the south.
And so the red property is what type?
Those are the hydric soils.
The blue is
soils with hydric inclusions.
Okay. Because I can't read that at all.
I'm sorry.
And also, the area that you're saying will be the 52 acres of development is that little blob?
Yeah, it's the dark outline of the property. That's the approximate area.
That's not set
No.
or anything. We have to look at the soils first, and no borings or anything. This is just county's map,
Correct.
soil map
No,
information.
that's correct.
Okay. That's all I have right now.
Yeah.
I have a question for the attorney. You stated that there has never been any real interest in anyone acquiring a property for residential. Is that correct?
Yes.
Could you explain?
Solely residential, as it is zoned, there's been no interest in 80,000 square foot lots, single-family detached. That's correct.
Okay, and could you explain a little bit about the Tallman development proposal? I don't know too much about it. Could you give me a little history on that?
You know, I'm probably not the best guy to ask, but I'll tell you what I know. Back many years ago, 10 or 15 years ago, the Tallman group out of Michigan, who everyone probably knows, a very large shopping center developer, sought out this property. They thought it was very well located for commercial/retail development. Now they do a lot of studies on this sort of thing. They don't just throw a dart at a map. This was for them ground zero because it was appropriate in their mind for their type of development. I think the development was probably 1.2 million, 1.3 million square feet. It was a rather significant development, and there was a lot of opposition to it, and ultimately Tallman pulled out of the deal, and what ensued was all of these various agreements which I detailed in my discussion. But it was for a regional mall. It was much larger than the square footage we're talking about here. The maximum, depending on the mix use, and based on the area that we've said we would not exceed, would be 800,000 square feet, but that's under perfect circumstances. That assumes you got the right mix of uses and the parking all works and all of that within our envelope. So that's the high end, that's the top. With various types of uses, it could be significantly less. It just depends on what somebody wants there. Now you contrast that with, 1 million, 2 million, 3 square feet. You can see this is a significant reduction and a lot less impervious surface and paving and parking lots and buildings and roofs. And we learned from that. I mean, the issue is we've got some people coming in saying, I'm not even going to look at this property. We've got others who came in with a very, very large proposal, whether appropriate or not, that wasn't for me to decide, and they withdrew. And so now, being realists, we look at it and we say, okay, we just want to solve this problem. We just want to get beyond all of these, what we believe to be conflicting agreements, and bring some clarity, make a lot of concessions, ensure high quality, and move on. And so this is very much different from this Taubman proposal, and it is much less intense, and I think preserves the environment in a pretty good way.
Thanks, that's all I have.
Okay, thank you.
Fire?
I have nothing at this time.
I've got questions on the buffer areas between the residential, where it buffs up to the residential areas which are north, east, and I know on the south side it's a pretty substantial buffer right now. But the pattern didn't really give any distances as to how far in, I guess, the first building may be. I know there's no specific plan, but does anybody have any idea in feet how far the well, I know there's no plan, but they're talking about substantial open space, and they have an area where they're proposing to build all the buildings and the parking and everything.
If I may, Eric Wagner has a lot of the statistics on that. I would defer to him if that's okay.
Okay.
Oh, the mic is off. Oh, as it relates to you referred to the buffer area between buildings and the property lines. Regarding the buffers, those are, we refer to those as setbacks. Setbacks are proposed in the applicant's preliminary development plan, which is in tab 5 of your application packet. If you'll refer to that preliminary development plan document, that's a fold-out document, on the lower right corner of that document, and I'll give you a minute to look at that, the setbacks are provided for all of the property lines for any development. I'll go through them quickly here. The setbacks, as it relates to the south property line, which you had asked about, is 150 feet. The setback to the east property line is 1,000 feet proposed. The setback proposed from Old McHenry Road would be 150 feet. There's a 100-foot proposed setback from Rand Road, which is US Route 12. That's the buffer area that you referred to.
I am particularly concerned about the setback Old McHenry Road. It's only 150 feet, which to me seems fairly close. And I'm assuming a lot of those buildings are going to be visible from residents right across the street. I mean, from what I've read so far, I think you've got a good plan, but I'm concerned again about the visibility of the mall to these residents, particularly right on Old McHenry Road. There isn't much. To the south, there's already a berm there and a lot of vegetation, and I'm sure you're gonna, or the Dimucci, or whoever develops the property is gonna improve on that.
Well, in response to your question, Mr. Chairman, the Zoning Board of Appeals, in the context of the application materials that you've been presented, in the context of any public testimony that comes up in the context of the public hearing in the coming weeks, you have the authority and the purview to review those types of issues, the setbacks for buildings, for example, and to, in your professional judgment, determine whether the setbacks that are proposed are appropriate and minimally sufficient to mitigate those impacts. You have the right and authority to recommend conditions to the county board that would alter those and modify those, and that's within your control.
Well, you have a little more expertise than I do as far as developing something like this. And again, I'm worried that 150 feet is just not enough on that particular line. But
and to that point, as to staff's professional expertise, we also rely on the record and any public testimony that's been provided. And as we wind through this process in the coming weeks and hear testimony from the public, we'll, as staff, have the opportunity to evaluate that testimony as well. And as I noted in my initial remarks, staff will have the opportunity in its closing remarks before the ZBA conducts deliberations to recommend any additional conditions that we see appropriate given all the information that is presented during the public hearing.
Thank you. There are not going to be any mall-type buildings. I haven't read anything in what I have. A shopping mall type.
When you say multi-buildings, what?
Well, inside, all of this.
Oh, an enclosed mall type concept? Is that
everything in the pattern book to me appears to be individual shops that may be connected.
Yeah.
And everything, but they reach from a parking area or sidewalks. Mm-hmm. There's no buildings that I saw in the pattern book that look like a mall where you enter a mall entrance and there's numerous shops in there.
Yeah. Nothing has been defined yet. I think the trend, I think the trend is away from malls. I also think that you should make your appropriate comments in that regard. So I can't tell you what the ultimate user is going to want to do, but I think your input on that would be encouraged. I also wanted to note with regard to GC in general, the setbacks that would apply under GC are a fraction of what we've proposed here. That doesn't mean that we won't listen to increased setbacks from you. We just want to see this all go together as a unified whole that works, rather than something that gets massaged so much that it results in a development that doesn't look right. The other thing I wanted to comment on is when you see a potential development area, the idea there is that we show the location of the improvements to be a Route 12 oriented type approach. The potential developable area is an area within which improvements would be made. We've limited ourselves to 53 acres impervious surface, which would also include the roads to and from. And there's only so much of that development area that you can use given that restriction. So ultimately, It is not clear whether buildings would be anywhere near Old McHenry Road. But if you need to propose safeguards to ensure that in that area, we will listen to any reasonable proposal.
You're proposing an entrance off of Old McHenry Road?
Yes.
Has anybody done any studies as to how much traffic that's going to put onto Old McHenry Road?
The issue is, for example, if it were all retail, and I'm not a traffic expert, I'm just giving you an answer that you can live with it or not. People come all day long, and so there's no set time. If it's office buildings, people will show up usually at certain times and leave at certain times. So the use will dictate the traffic pattern. And of course, in all of this, and we've said all along, that there will be all the detailed traffic studies, warrant studies, those types of things when the actual mix is known. In addition to that, we have to comply with the Lake County DOT approval permit standards for Old McHenry Road and all of the IDOT standards with respect to access to Route 12. So those are currently the controls in place, and we will certainly analyze that to everybody's satisfaction when the mix is known. So this deal will not go forward into any kind of final approval stage without all of the studies based on the use mix. And we're fully aware of that.
Thank you. John, you got anything?
Yeah, just to follow up on what you're talking about, are you prepared for deceleration lanes, left turn lanes, and so on and so forth? Or
Yes.
are you going to?
Yes, I mean, you always have to be prepared for that in a matter of this size. There may be specific impacts at the intersection that require improvements. There may be specific impacts on Old McHenry Road for accel, decel. Yeah, I mean, all of those things will be taken into consideration, and they are expected.
And subject to signalization as well?
Yes, there'll be a warrant study.
I'm a little bit miffed that these things haven't been presented at this point.
The reason for that is because the actual use pattern is not yet known. If it's all retail, it's one thing. If it's all office, it's another. More likely, it would be a mix, and that will determine the nature and extent of the improvements. Those will all be studied before any final approval could be given.
Thank you.
Headed, John? Thanks. Carol, you got anything? Sure. Down here? We're pretty much, we're almost at 9 o'clock, so I think this is a good time to shut it down. And when we come back, we'll start with the questions from people who want to cross-examine. I do need a motion. Staff, we have this room reserved for the 25th?
We have the room reserved for the 25th, should the ZBA decide to postpone to that date.
So for what date?
Should you propose the 25th, we have available.
Okay.
Mr. Chairman, make a motion to continue this meeting to July the 25th, 5 p.m.
Second.
One point of order, please, before you conclude.
Yes, sir.
I know that the applicant indicated that they were going to be providing a copy of all of those exhibits to Mr. Tierney. I think certainly on behalf of Baker, but also on behalf presumptively of the villages, we'd ask that a copy of those be furnished to us as well. If for no other reason, I think it'll enable us all to prepare a little bit better with the cross-examination. Will probably expedite the process.
I might point out that the Clarion report I am told, does not
think it's...
Can you provide them with that information?
Sure, but I think as a matter of logistics, what I'd like to do is give to Mr. Tierney multiple copies of each, and then he can distribute them, or you can feel free to come to the county and pick those up.
Put it up on the website.
Wait a minute, I had a motion on the floor.
Right, Greg?
Second?
Second.
Second by John Reinkel. All in favor?
Aye.
Mr. Chairman, if we could get some assurance from either staff or the petitioner that we can see all the exhibits that we're seeing out for the first time tonight within the next 48 hours, we'd like that assurance.
John? That's all right from your standpoint. Huh?
Mr. Braithwaite, got that subpoena.
One of the village attorneys, I believe it's Dan Shapiro,
I did not date it.
is asking that all of the exhibits brought out tonight by the Dimucci family, none of which have been seen before,
Paper copies, some thumb drives?
that they will be available in the next 48 hours.
I want to be sure it's all organized appropriately.
There are a huge number of people here who had signed up for public comments. Certainly nobody
We are adjourned
to sit
until
here all evening. This meeting is continued until Wednesday, July 25 at 5 p.m. again at Concord Banquets. So we will make every effort to be here and film those events.